Our today's topic is H2A, temporary agricultural workers. So, before I talk, go talk about this. So, under this visa, American farmers they can bring foreign workers to work as a temporary worker, and this is a very good opportunity for foreign people to come to America and have job in agricultural sector. So, those who have like agriculture background, this is a very good opportunity for you. So the first question is, what are the preconditions for the petitioners? The petitioners means like a farmers, or the employer who are going to employ you in the farm or any other company, agriculture related company. They're the petitioners. So what are the requirements? So to qualify for H2A program, the petitioner must either be a U.S. employer, a U.S. agent, or a member of a U.S. organization of agricultural producers who is also listed as a joint employer. So, these are like a legal legal discussion, but in short, like if you are a farm owner, if you are a farmer, if you're an agent, you can employ people from foreign country to work in American firms. All right. So to submit a non-immigrant worker, and this is the continuation of previous topic. So to submit a non-immigrant worker petition with USCIS, the petitioner must, these are the recommendation, demonstrate that hiring an H2A employee will not have a negative impact on the working condition or wage of US workers in a similar field. Meaning that they need to establish that bringing this foreign labor is not going to have any negative impact on the local community's work environment. Then show that the position could not be filled by a qualified US worker who is also available, willing, and able to perform the required job. Again, what it means is that the farmer is not finding qualified people in the local community. That's why he or she is bringing foreign labor to the America. Attach a valid temporary labor certification. Of course, we are going to talk about that later. Provided by U.S. Department of Labor to your to a petition, except in emergent circumstances. Offer the beneficiary a seasonal or temporary jobs. This cannot be a permanent job. This is a seasonal or temporary job. That's all. This is the very crucial topic of our today's discussion. The entire thing is for seasonal or temporary job. To obtain the required temporary labor certification, employer must satisfy the following eligibility criteria: must be an employer with a valid federal employer identification number, FEIN number. All businesses here in America has FEIN number, and a company that is physically present in the United States. This is very important. A lot of people, they ask me question, hey, I have a company in a foreign country, can I bring people to America? The answer is no. If your company is physically located in a foreign country, you cannot bring worker here. Also must be seeking to fill roles that are agricultural in nature. So this agricultural in nature is also a very controversial / subject to interpretation kind of topic. I'm not going that detail about this. If anybody has any specific questions, please reach out to me. I will see if your employment is agricultural in nature or not. But in general, it must be related to agriculture. Must be looking to fill a full-time position. So this is a full-time. It's a temporary job. It's not a permanent job, but it must be a full-time job. It cannot be a part-time job. All right. So this is the precondition for the employee or beneficiary. So previously we talked about what are the preconditions for the employer. Now we are going to talk about precondition for the employee or beneficiary. The prospective employee must be a national of a country found on the eligibility country list, which is updated periodically on the Federal Register. So to be qualified as a employee, as a beneficiary of H2A, there is a list of the countries, and US government, they update this list every year. So you have to check whether your country is listed in that list or not. If you are not, you can still come to America. That's our second topic we're going to talk. However, it's way easier if your country is listed as one of those enlisted countries. Countries remain eligible for 1 year after the list is published. Employers may, in certain cases, hire workers from ineligible countries, but in that case, the petitioner will need to provide more evidence with their Form I-129. All it means is, even if your country is not listed in that list, you can still come to America. In that case, the employer needs to provide some more information, more evidence, and which is not very tough. We can help the employer. So Short answer, yes. Even if your country is not listed as one of those countries, you can still come to America. All right, dependents of H2A. So the spouse and children under the age of 21 are qualified as dependents, and they can come to America under this visa. Cost. So this is a lot of time people ask question about cost. So for the temporary labor certification, the labor department charges a $100 application fee and $10 per certified H2A worker. So all it means is, let's say the company, let's say the name of the company is ABC Agricultural Corporation. They are going to file one LC, one labor certification for that, and for 15 beneficiaries. So one LC for 15 beneficiaries. So all they have to pay is $100 for the LC and $10 per beneficiary, meaning $150 for 15 beneficiaries. So the total would be $1,600 to USCIS. Then to file the form I-129, the US employer will need to pay a $460 filing fee. The prospective employee for their part will need to pay a fee for their non-immigrant visa application if they are living outside of the country. So first the employee already paid like $1,600 in our example, and then they also need to file $460 for I-129 form. Then when the beneficiary is coming to America, let's say the beneficiary is living in a foreign country, they also have to pay for the visa fee, embassy fee and other things. So they must bear that cost. Also note that premium processing is available for I-129, which takes the USCIS to give the decision within 15 days, and it costs $1,500. So this $1,500 is addition to the $460 filing fee for I-129. A lot of time people ask me question, hey, if I apply for premium processing, do I still have to pay $460? The answer is yes. The $460 is the filing fee, and $1,500 is the premium processing fee, not the filing fee. In total, it would be how much? Like $1,960 kind of thing. All right, steps for H2A application. So, there are three steps. The first one is petitioner applies for a temporary labor certification with the Labor Department. In short, we call it DOL, Department of Labor. Once it is approved, petitioner files form I-129 with USCIS. Once it is approved, and then if worker is living in a foreign country, they apply for non-immigrant visa. They face the visa interview in their local US embassy, and then they come to America. However, if the person is already in America, they don't need to face any visa application in embassy or anything. Or there are some countries, they don't need visa to come to America. They can just directly cross the border with this approved H2A visa, H2A application, and they can come to America. So it depends on your circumstance, whether there's a third step or not. So this is the three steps for H2A application. The first step, apply for temporary labor certification. Let me go a little detail about this. So first, the employer, the petitioner needs to file form ETA 790/790A between 60 and 75 days prior to the first day of work. So let's say the employer intends you to start working in January 1 of a certain year. So they must submit this form ETA 790/790A within 60 to 75 days prior to January 1. Because it takes some time to get it approved, get the visa and other things. So they must take have enough time in their hand before they can apply for you. Then a cover letter attached to the job order application is stating that the employer intends to file petition for H2A status, of course. And then after ETA 790 is approved, then they need to submit form ETA 9142A at least 45 days prior to the first day of employment. So these are the things. A lot of time beneficiaries and employees, they don't know about these things. They don't need to know about this. I'm just giving, talking about all these things just to give you an idea. If you don't, understand anything, that's okay. These are the things for the lawyers. The lawyer and employer, they will work together and they will take care of all these things. Last one is any other requested material for H2A, contractors. This is kind of like a catch-all kind of situation. In every application, every petition, we need to submit a lot of supporting documents and evidence. This is these I mentioned in this topic. All right. Second step, submit your form I-129. Once your temporary labor certification is approved, then the next step is I-129. The employer may request more than one worker, but no more than the maximum number set by the temporary labor certification. Workers may be named or unnamed, but the employee must be named if they are. So these are the requirements when the application, when the petition must name the workers. Number one, they're present in the United States, not a national of an eligible country. I told you before that there's eligible countries, but there are a lot of people, they're not from eligible countries, but they can still get this visa. Number three, required to satisfy the job requirements as stated on the labor certificate. So they must satisfy all the requirements mentioned in the labor certificate. And this is the continuation of previous slide. By the way, the way I make this slides and things in a way that even if you have difficulty understanding my English, because English is not my first language, you can read these slides and you can understand this. That's why I make these slides so easy for you to read and understand. So the employer may hire workers who are not from eligible countries. In such case, USCIS recommends submitting separate petition for those employees. The employer will also need to do the following. Number one, provide the name of all of the prospective workers who are nationals of ineligible countries. Also, attach proof showing that it is in the interest of United States to allow the prospective worker to enter the country as part of the H2A program. All it means is like we need to submit a letter claiming that bringing these employees from unlisted, not listed countries is beneficial to America. And, we can do that. It's very easy to do that. All right. Third step, prospective employees apply for H2A visa or enters with H2A classification. So as I said, the people who are already in America, they don't need to follow this step because they're already in America. If you are in a country where you need to get a visa before coming to America, you have to face a visa interview, apply for visa in your local US embassy, get the visa and come to America. However, there are some countries you do not need to get a visa. You can directly come to America crossing border with just a H2A classification. It depends on your background. If you have any question, let us know. We'll answer your question for these steps. Also, when you apply for visa, you need to apply with a valid passport, photograph, confirmation page of DS 160 form, receipt for the application fee, receipt of approved I-129. So these are the requirements of visa application. When you do it, all of these things. And if you have question again, let us know. We'll help you. The employee can also enter through a border with H2A classification with an approved notice. It depends on the country. If you are from a country where you don't need visa, you can do it.